Okay, clause 18, paragraph 18, stresses the need to enable automated analytical techniques for text and data, in other words, text and data mining, for all purposes, provided that the permission to read the work has been acquired, in other words, have lawful access to it. So she is stressing the need to enable that to occur. The next one, 19, calls for a broad exception for research and education purposes, which should not only cover educational establishments, but any kind of educational and research activity, including non-formal education. Link those two together. Then 23 stresses the effective exercise of exceptions and access to content that is not subject to copyright or related right of protection should not be hindered by technological innovation. In other words, if the publisher has instituted some sort of digital rights management system or whatever type of basically said, you can't do this, just said the technology says you can't do it. It said that the effective exercise of exceptions, like the text and data mining one, should not be hindered. It should basically say you can't use technology to stop people doing it. And she also said that if there are any such technical measures which are in place, the source code should be made public of those technical measures so that people can justify certain navigation. A couple of things she doesn't say without it. One thing she doesn't say without it, like was that she doesn't say it should be an offence to impose technical measures where they're not justified. I would like to see that rather than just have it open system on the rights, it should actually be a legal offence. And I also would like to see companies to say it should be an offence to claim copyright where you don't have copyright, or to threaten infringement actions where they are unjustified. Which is actually something which does exist in patent law and in trademark law, that it is an offence to actually threaten infringement action when it's not justified. So, but nonetheless, that's for later. So, what happens next? If the European Parliament...
Quick question, Charles. So, there wasn't anything about overriding other contractual...
Oh, that is correct. So, unlike the... Thank you very much, Peter. Unlike the UK law, which says if you've signed a contract and it prevents you from doing text and data mining, you can just ignore that bit of the contract. She doesn't recommend that. That's something else I would like to see. That any contractual clause which purports to stop you in text and mining shall be deemed invalid. Thank you. So, what happens next? It will be discussed by the European Parliament. Lobbying has already started. I've seen comments from publishers, because I followed those publishers discussion saying this is absolutely disastrous, this is dreadful, what woman is proposing. They've asked for meetings with her. She'd already said that she'd had so many requests for meetings from rights holders, and she actually said, I want to have meetings with users, and users please come and talk to me. What do you say?
And authors. Yeah.
And authors. Indeed, every interested party. She says she doesn't just want publishers. And it could very well be that publishers successfully lobby their various MEPs that when this report finally comes up for discussion, that enough people are opposed to it that they either water it down or that's perfectly possible. If the European Parliament doesn't, then we've got further stages. It has to be converted into an EU directive, and that requires a central council of ministers to be involved, and that's a minister from each member state who happens to have responsibility for intellectual property law. So once again, the rights holders will undoubtedly be lobbying their ministers saying, don't let this happen. So I'm not saying this is going to happen fast. It certainly won't. It may well be 3, 4, 5 years before anything happens, and it may not be what they're after. But for the time being, the UK has its advantage.
And also, just to say that even if a directive is passed, it is then up to each member
State to implement it as it sees fit and precisely the wording that it wants to do, and it has maybe 2-3 years to do it. But in the case of the UK, it wouldn't make that much difference because we've got our political law, but for other member states.
But also, just to interpret that, if it came in as a directive, it would actually expand our rights here because it doesn't mention non-commercial.
Indeed, it doesn't. But I'm sure the rights owners will get that stuck.
Do you think they'll win?
I think they may well win, unfortunately.
Oh, that is a pity.
Yeah, I'm sorry, because that will make life so much easier.
Absolutely.
Because what's commercial, what's not commercial is the real sort of problem area.
Yes.
It really confuses you. So, it is certainly up to outlets like ContentMine to congratulate Miss Rader on her wonderful piece of work. Very written, well argued. And it's not just text and trademark. She made all sorts of recommendations, like the lifetime of copyright should be reduced, which would also would be a good thing. So, instead of life plus 70, she wanted that down to life plus 50, which is very good. But it will be very interesting to see what lobbying goes on. But organisations like ContentMine, researchers who are doing text and data mining should be saying to Julia, all power to your elbow.
Well, I tweeted that I thought it was a great report, and I got a reply from her. So.
Oh, very good. Yeah, oh, very good.
Can I just add a couple of brief things? I mean, if you look at the first one, is
so does everybody know?
Sorry, I'm used to the Royal Engine this time now, Pacific, so I don't know what I'm doing with my life.
So you know if
the intellectual property department. It's a plug, really. The first thing is if you want a relatively robust but well-written take on copyright, well, there's a site called Copyright User Org. Which is put together by Bournemouth University.
It's very good, actually.
So
were you involved in that, or your group?
Well, not really. No, but,
okay.
I mean, yes, there's a kind of circulating around like that, and that's got a take on text and data mining, which you may want to look at.
Yeah.
And also got links to various things. One thing you might want to look at, because it is written in law, but it's worth having a look at, is actually the legislation itself. It's easily to find. If you want to go in section 29A of the copyright design. And there's a link on the copyright. The only thing really to add is that there are a couple of wrinkles in the defence and the exception which you need to be aware of. One which has just been mentioned. The computational analysis must be for the purpose of non-commercial research as one, which you need to bear in mind. And the second is an interesting one, which may by people in the band who don't know it, is the copy is accompanied by sufficient acknowledgement, unless this is practically impossible.
Yes.
So you can see, I mean, lawyers make money out of ambiguity, and publishers put pressure using ambiguity, and you can see that there is an ambiguity. So what does it mean? The way the common law works is you don't know until it's been litigated. But you can see how at this stage there's an element of risk as to how that's going to be.
Yes, you can well imagine. Well, I mean, it's straightforward if you're just searching a widening database, you just say copyright widening. But if you've collected together stuff from all over the place.
One of the wrinkles is does one know for sure who owns the individual elements of copyright within the database? So you say you never assign copyright.
Yeah.
So you can see how it may well be that someone within the wider database rights that are not owned by Wiley, and you haven't given sufficient acknowledgement to the right owner because it's only snoops of 35 cuttings each tune. And he brings it.
So
we were discussing this yesterday, weren't we, in terms of obviously we're currently not storing stuff that is not well. So we're mining CC BY material mostly, and we're not making a permanent file store of it. We were discussing whether it would be worth making a permanent file store, and then the fact that even within CC BY licensed scientific papers, you might have a figure that's been permission's been given to include the figure, but it's actually under a different
Yeah, there are, I mean, that raises another issue as well as the one you mentioned, is the further dissemination of any copywork you make. So what happens to that? So you've made one copy of a table like Danbury. Of course, it's not just going to sit there and be one. You do something with it. You do something with it to make a copy, because that's the reason it works. That's a big copyright violation, actually. And the provision deals with that as well, and it talks about when you are transferring a copy to another person. And it creates new regulations when you do that. And ultimately, it seems to be when a copy of the work has been made under the section, which is what you've done, copyright with the work is infringed if the copy is transferred to another person, except where the transfer is authorised by the copyright owner. What does that mean? It could mean that while you say, okay, you can mine it, you can't do anything. Yeah. Which, again, I come back to the point about lawyers and their Maseratis and they're running out of ambiguity. What you're dealing here, okay, so that's what the law is. Then how do you run an operation? The question comes down to what we're talking about. It's a question of risk. You have to be informed about the law and then take an informed decision about what that's risk about. That was the end of it.
Yeah, no, I think that's great. So, since this is going out to the world, we have nothing to hide, and I'm absolutely clear about that. Let's review these things. First of all, we intend to make advantage of what we had rightful access to do before the Harvard's, which was stuff effectively under a CC BY license or a CC 0 license, and for the body of the text, we'll come to images in a minute, but for the body of the text, we believe that CC BY is sufficient to authorise us to do any reasonable thing with that, as long as we acknowledge it. Now, we are committed to acknowledging. There are one or two technical problems with acknowledgement, which is that if a work then includes references to other works which are included within it, you get sometimes a nearly infinite regress. But I think that if we make an honest approach to trying to acknowledge people, that will be sufficient. And I also don't think that those people, as moral rights holders, as opposed to intellectual property rights holders, will feel that if they are, the second footnote in references which are referenced by reference, that they will be in breach of that. Which we do our best. It's the best of the effort. I don't think that's a big problem, so long as we're aware that we know sometimes don't. The place where we have a problem with CC BY material in publishers is that sometimes, not very frequently, but sometimes image material is included from third parties who have the rights and who give the rights for it to be used in that particular instance. So they will say, picture of, let's say, someone said, I want to illustrate this with a picture of the Mona Lisa. So they will say, okay, this is made available by, where is she, the Louvre? By the Louvre Museum, and we thank them for it and so on. If we reproduce, although that picture, of course, is on the internet, everybody can see it, but we may not be able legally to replicate that, even though essentially it's having no effect for everybody else, other than slightly increasing the visibility. So we will certainly do our best technical endeavour, but it probably will be a technical endeavour to determine where those rights are within a sub-party. Does that make sense?
Yes, a little right on that. What you're heading towards is an immense problem with lots of copyright areas. So, for example, in the Mona Lisa, there's the image, there's the photograph of the image. So there will be a person who took that photograph.
Absolutely.
May or may not be, may or may not be originalities, etc. Not the same. So therefore, you've got there's a second about it. There is an organisation called the Copyright Hub, which is seeking to seeking to make this identification of rights holders easier than all of this metadata and so on. Ultimately, they always have one clear licensing. So this is a problem. There isn't a short-term solution. There are attempts to try and have problems with it. But yes.
So we have a particular problem with influence. which is that a lot of science is based on images, right? And I may differentiate.
Diagrams.
Well, exactly. I was going to use the word diagram, right? So what we differentiate between roughly is an image as a photograph, right? A set of pixels from which you can't do anything else other than use the image to get this together. And a diagram where we can extract the semantics of that diagram without reproducing the diagram. Are you happy with that?
Partly, there's a wrinkle there, in that the definition of what reproduction is slightly acute to what we're doing there in some circumstances. So, for example, if you manufacture a brake pad from a diagram, so you can have non-literal reproduction, which in some circumstances is considered reproduction. So that's the wrinkle there. So it may or may not. You may not have a clear get out of jail. I'm sorry to throw ambiguity into this, but you may not have a clear get out of jail card that includes it in text terms what you have.
That's a good point. Okay, so what we have done from the beginning of ContentMine is to say that we extract facts, right? And we use the word fact because facts are uncopyrightable. Obviously, what a fact is going to be ambiguous as well, but we take it to something operationally. Legally, the operation is whether the judge finds it's a fact or not. Right? There's not much you can do about that. Operationally, it's whether we can turn it into a semantic vocabulary and restore it, so round trip it without losing information.
That's very sensible. The closer you can't, because copyright in general terms only protects expressions, not the ideas behind it. However, as with copyright, there are nuances you've got that counts around it, and there are some ways it's been encroached. I won't go into it. I could briefly go into it. So J.K. Rowling, for example, remember she was sued by somebody who wrote a similar book about wizards. Dan Brown was sued by somebody who wrote a book about copyright. Now, what they were saying there was a non-literal copy. And what the defence was is this was an idea. And in those cases, you see some sort of policing of this unstable margin. Leaving that aside, I think what your approach from a practical point of view is very sensitive. The closer you can come to relaying a fact rather than expressing a fact, the closer you come to.
So, to give a concrete example, do you know what a chemical structure diagram is? Well, it's a picture of a molecule. So, a benzene ring is a hexane. Now, there is virtually no other way of communicating the nature of this compound scientifically. That is the standard way of doing it. We have semantics. I'm a chemist, we have semantics that actually allow you to translate that picture into the fundamental representation, and then to redraw it with some other tool and so forth. Now, I would argue that the visual formula of acetic acid or benzoic acid or whatever was extractable into a non-copyrightable fact, because otherwise you cannot communicate the object.
Well, yes, expressing the exact point and agreeing it, expressing in slightly different legal terms. The diagram is only protected under copyright if it's original. And originality in European terms involves some expression, making creative choices, expression of its personality. It's difficult to see how a diagram of benzene ring absolutely can engage the author's personality. Therefore, it's difficult to see how it's original. Therefore, it's unlikely to
And even if we're talking about a brand new compound which had never been synthesized before, because it follows the standard rules, as you rightly say, for the work, I don't think that can be claimed to be an original.
So you've got on that specific example where you have the very minimal amounts of no originality in your diagram, which is a strong argument given the example. But supposing you have a novel way of using forms to express a chemical reaction, then you are
That's a different matter.
Absolutely, and we recognise it. So, for example, my partner Judith, in structural biology, and she drew pictures of how proteins work and so on. And in my view, they were protectable because they were, an imaginative expression are humorous.
So you're obliged to say this, really.
Absolutely. And so when you explaining how something works, it can be. So we had some examples here. One of the examples was apparatus. So if you take apparatus, would we be able to distill that into a semantic representation and reproduce it without violating copyright? And I think it's on the borderline, right? If you take a flow diagram of a computer program, right, then if that is the only way of describing that program, then it seems to me reasonable you can come up with semantic representation.
I don't know enough about flow diagrams or bits of software, but presumably follows the same sort of rules as with chemical structure diagrams, that they're absolutely standard ways of representing particular activities.
I think that's right. Yes.
There is a particular area, computer programs in particular area, which I'm not up to speed on. So I'm just put a marker down there. It seems plausible to me, but computer programs are an area of art. Unfortunately, I apologise for saying so.
No, that's okay. I mean, copyright doesn't apply to computer programs, but we're thinking of something different here. I mean, we're thinking of stuff which is, I mean, you could argue that a flow diagram was copyrightable as a program which wasn't explicitly licensed under a liberal license. So yes, if I write "Hello World," copyright very much, then that is a copyrightable, right? But normally I would say "Hello World" under a Patch 2 or an HD license, which specifically, I mean, sometimes with description, sometimes not. So I would say that diagrams are an interesting area here, and take on board what you said. One of the things that we can do now is we can take graph plots, so the plot of X, Y, and so on, and we can turn them into a table. Right? Now, I would argue that is that the data in that table are facts and not copyrightable. We'll forget about the silly generis story.
I was going to agree.
Well, mention it now. Yes.
So, a compilation of facts can be copyrighted in two distinct ways. Databases and everything, but it's actually more broad. It's a user compilation of facts. If it's original, it is copyrighted. If it's not original, but still has seen a significant amount of expenditure and explanation, it can be copyrighted, it can be protected under something which isn't copyrighted, which is similar. Then the distinction is what is original, and original doesn't necessarily mean new things. Original in current parlance of European law is something which isn't expressed by authors created intellectual personality was involved in creative choice. So you've got those two different things. What flows from them is slightly different as well. But note that there's two tiers.
There's a question or a comment.
This is actually just going back to the beginning about what it matters what you do with the data. So given that it's legal in the UK and Japan, but it's more a grey area or illegal in other countries, what about accessing the fruits of an illegal activity in that country? So given that it's hard to do this data text mining in other countries, what about us making that data available across the world?
Okay, you're talking about two different things here. If it's legal in the UK to do it, to actually do the text and data mining, and you've got the product of that text and data mining, and that product, say ContentMine says help yourself world, it is available under Creative Commons license, then third parties can take it. But the general rule is that if you take something which is clearly infringing the example I would give would be YouTube. But if you go to YouTube and you take, a copy of a recently released film and you copy it, you incorporate it into the thing, and you say, well, it's okay because YouTube said this is available under Creative Commons license. So that's not really a defense. It's really obvious that what made it being made available was infringing. So you've got to be careful about taking stuff which is clearly infringing. So if that third party will have to make their own informed judgment, can I take it? And what risks am I taking by taking this stuff?
But we certainly can, where what we've extracted, we have judged as a fact.
Yeah, absolutely. As long as you're happy
that we would be making those available
yes,
as
absolutely.
CC0 public domain facts that anyone can ingest into their system and analyse. But like, I think going back to a few points in the conversation, what we wouldn't be making available is the source of that, the full source of that fact, just the fact that it should be exposed.
Little clarification, I think, using the word what copyright does, it protects a series of different actions. It doesn't protect anything.
Sorry?
You can throw it away, that's all, yeah. It protects a whole series of facts. One of the things it protects is reproduction. A whole different series of things it protects. Performance. But one of the things it protects is making communication to other people. You automatically use those terms, you automatically use them. I'm just highlighting the fact, a distinct particular act which is regulated.
So, to summarise where we think our major policies are, one is to extract facts from anything we have the right to read, and to make those facts available under a liberal license. At the moment, we believe CC0, and that applies to any document that we have the right to read. I would note that, unless it might be different, that this has been done for over 150 years by humans extracting from the literature. So many activities take the literature as it is and extract facts from them and make compilations without, I believe, requiring permission of
a word of caution there. In the course of the act has been done in the past by humans, and now it's done national body computing. You shouldn't necessarily be saying. So, an example, the business of making summaries of newspapers, which is now just it has for many years been done by people reading newspapers and copying them out by hand. But there's been a lot of litigation about whether the automation of this is copyrighted.
That's very useful to know.
So the fact that you've had a manual activity which has now been automated shouldn't give you complete confidence.
Nothing gives me complete confidence.
I apologise.
No shit, Sherlock.
But that is one of our activities, right? We're going to take whatever we have a right to, extract what we believe are facts, what we call offending causes facts, and make them available. And we're going to do that in a non-competitive manner. So we are not going to charge people for them. We cannot obviously regulate their downstream.
Can I identify the levels of defence in what you've described? Number one, what you've said is a fact, so therefore copyright doesn't apply to original material. So a fact is not protected by copyright. Number two, you said you've used material which you've had access to in a way that maybe because you have used access to it, it actually commits the license activities which you're subsequently going to do. Number three, you're employing the data mining defence. Now all of those are cumulative and separable. So you've got a kind of three-layer thing.
So are you saying that each strengthens the other, or
Yes.
each? Right.
It's three layers of defence.
Right. The second thing we intend to do, and this is fairly recent, it's fairly obvious, we're not going to be the only people to do it, is to take what is regarded as we'll call it open material, but CC by material which specifically says that you have a right to read it and copy it and modify it and disseminate it. And we are going to do that And that will only run into problems, it seems to me, as if we fail to acknowledge in some way or other, if we misidentify the material in some way, or if that material contains stuff which isn't covered by that CC BY license. Otherwise, I don't see that there are things which we should legally be concerned with. Is that fair?
Well, applying what I said earlier, so if all the material you're doing with is facts, then
No, this is non-factual.
So if it's non-factual, then the subsequent things fine. Note how, I mean, it is reasonable, but note how now we're falling back on primarily relying on the text mining defense section from the 9A.
Are we?
Are we not? Sorry,
No, if something is CC BY,
yeah.
right.
You've got the permission to do it anyway.
So you don't do the
Yes,
exact
yes, so the problems come if it isn't actually CC BY.
You've got nested rights. Yeah, if you're one of the low level of rights, in fact, is protected, then so that's one.
But this is stuff which is advertised by both the author and the publisher as being available under license to copy, reuse.
In that situation, you have a potential subsidiary contractual action against the person you arrived at it from, assuming there's a contractual relationship. But there will still be, potentially, if you've reached an underlying copyright action.
Indeed. So the two things are if it's mislabeled in some way or other, or if you've misread the label, which isn't quite the same thing, or if there is a part of it to which that doesn't apply. Now, we will obviously carry out best efforts, right? I think we have to be prepared to react quickly and positively to any concern of potential rights holders. Let me give you a counterexample, right? I published in open access journals, I'm not saying from, and I published, I don't know, 20 papers there or something like that, and I discovered that Springer, who owns Biomedcentrale and a lot of us, had taken every image that passes through it, every image, and copyrighted it, and written copyright Springer over it, and was selling it for $60 per image. So they had clearly breached this license, and they have a product called Springer Images with about 3 million images, which is the scraping of all of their content. Now, it's not the same thing, but what I'm saying is that they had not given any concern about my rights.
So what you might want to do going back to before that example, what you described you were doing is what you're seeking to do therefore is rely on your supplier to possess the rights they purport to possess.
Correct.
So what you might seek to do therefore is enter into a contractual relationship with your supplier, so that if it turns out they don't have the rights which they maintain that they possess, you have an action against them. That protects you against something you may want to consider doing, you may not want to do, but that protects you against a potential action from the original.
The problem with that is that people want to just go ahead. They don't want to enter into a contract. They've got lawful access to the material, and in any case, if they entered into a negotiation, the supplier may well say, "No, I'm not prepared to let you."
So that's a downside, and that's an argument not to do that. In which case, you would fall back into valuation of having a full opinion that this is, they may not be selling what they say they're selling.
And this is exactly why I said I think it ought to be an offence to claim copyright on something you don't have copyright in. That's precisely.
Although I guess in a large part that's going to be a problem where you've got hybrid journals. I suspect it's less the problem where you've got an entirely open access journal.
Oh yeah, sure.
It's clear from the outset. So in that case, surely the suppliers would be the suppliers of we only have lawful access to the library. So that it would be the contract between the library and the journal. So
And
the
that is true.
librarian
And that is true. And there will certainly be an indemnity clause in the contract between the library and Springer.
so it might already
In
In which direction?
No. It will be an indemnity clause
So
that says if somebody is upset by something which they believe you the library or the library users have been doing stuff and they claim you're not allowed to do it, we, Springer, will handle the action on your behalf. It isn't quite the same thing as Springer saying we own this when they don't.
It's now getting slightly complicated if you can identify the amount of parties involved. So you have the original copyright owner, you have the person who's bundled the reports to have the copyright. You have the livelihood relationship with their supplier.
Yes.
And the lines of intellectual property claim are not aligned with the lines of contract claim. And there you get very messy litigation.
Yes.
Yeah.
Shame Yvonne's not here. We've got Yvonne from the library later.
Just one thing to mention, which is similar to what we're talking about, is supposing the situation you can't identify the copyright owner after diligence search. That's one that seems to be the
another.
total.
Yes.
I'm just mentioning it. There are provisions which deal with those, and they are to use within orphan works.
Yes. Yes.
So you may want to. This is slightly different, but just
So those are our proposed activities at the moment. We are starting with open access CC BY material because we're developing the technology and we want to make sure technology has very low failure rate and so forth. The other thing we plan to do with the I'll call it the not, let me call it the the closed works, because things which are behind the farm or a paywall. What we plan to do is we plan to copy those legally because we have access to the library. Right? We will hold that for long enough to make an extraction of the facts from the copyrighted material. We will publish the facts under a liberal license, and then we will discard the copy of the copyrighted material. That's the current model.
You might want.
Are you with me?
I'm completely with you. You might want to read a case called InfoPack. I don't tell people to read cases makes them read. But you might want to read 2 cases of the Court of Justice of the European Union. The reason why is this: I mentioned earlier on the model of press cuttings, which is kind of what we're doing. Similar, but on a much greater scale. And those cases revolved around an organisation which took a copy of newspapers for the purposes of then deriving the information from it, summarising, and then they threw away the original purpose of the newspaper. And if you read those, you're going to get an idea of how the copyright law is applied in a comparable, not identical situation.
But there is a difference, because InfoPack involved commercial activity. They were selling their service. Yeah.
I know morals don't count for anything in court. They might mitigate the sentence.
No, they do.
They do take it into account, and if you're a pirate,
yes,
you're quite clearly have gone way beyond the law, and you must get sent to prison for your activities, where you're deliberately damaging the commercial interest of the rights holder. Whereas if you're doing this for non-commercial research, that would be taken into account. I mean, it doesn't mean that you'll be let off the hook totally.
It's taken into account 2 things. Firstly, it's taken into account the law is strict liability, your intention is important. But your intention is important, for example, when they're considering what punishment if they find
exactly.
It's also relevant when they're considering whether to bring an action in the first place.
Absolutely.
And to that extent, if you've seen, take for example, the music industry's use of copyright action against the consumers in America. There are PR concerns in taking action against people who are using material over 2 days. So that it is entirely relevant.
Yeah. So, we intend to have a takedown policy or mechanism, both a technology and a mechanism, the policy. In the very few cases where there might be an honest violation of rights holders' rights. If we are dealing with, there's about 1.5 million articles published a year, it will not be impossible for some very occasional. I'm saying this to the camera because happen, and we will honestly respond rapidly to any request to take that. So that
helps as well. That helps you to Can I ask you a question, Peter, about the embedded images, the photographs, say? Let's just imagine now in a scholarly article, it has an image, and somewhere well down, maybe at the very end of the article, under acknowledgement, it said, we would like to thank Joe Blogs for permission to reproduce. Will your software pick that up and link it to?
The answer is, it is our intention to do that and fairly rapidly.
Right.
Although it's going to be difficult at the end, if it's in the figure.
Not necessarily. So the only things we're considering here are figures. We're not considering, for example, sonnets or something which is protected in the text. Yeah. We're taking the view that in science the only things which are going to have a value in their own are images, not text. So what happens with a figure?
Let's clarify that. The only thing which is going to
trigger this problem on a significant scale is images.
the problem of there being a copyright
Copyright on part of the work.
Yeah.
So what about if an article quotes another source?
Doesn't happen that much in science.
Okay, well that's fine. It doesn't happen. I'm just raising it as
So, yeah, it may
you can have
never-
nested literary copyright.
Absolutely.
I would say
If it doesn't happen, that's fine.
if we
Yeah,
did
if you
this
talk
in
about
arts and humanities,
humanity,
it will be
it will be a problem.
absolutely right, because people will say, I'm an art historian. I want to be able to reproduce this picture so I can show that the Mona Lisa got no arms and things like that. And they will have to write off to the Louvre. They'll have to get permission. If they want to quote Wordsworth, they've got to go off and get somebody's permission to quote. In science, the process of criticising parts of what people said has never, in my view, been subjected to copyright as a problem.
I mean, quotes tend to be very.
The quotes tend to be
Quotes in
very
there,
short if they are,
quotes
and it's certainly not in any way
So
analysed.
another relevance, there is an exemption of new representation.
Absolutely, yes. Yeah.
So the problem.
So,
Let's say that somebody goes out and they study frogs in okay? And what we've got is we've got two, and it's a short paper. It's got pictures of frogs, right? And it's got a diagram of, frog height against frog jumping or something like that, right? So one is a diagram and it contains dots or bar charts or whatever. The other is a picture of this frog, right? Now, the picture of the frog is copyright. Did you hear about the gorillas? The monkeys, sorry.
Yeah, the monkey selfie.
yes.
But
That was copyright.
yes,
Yes, indeed.
Who was the first
So-
creator?
so there is a potential problem in science. Ross is the expert on this, but in science you have to use photographs in many cases to represent your raw data. So this is a picture of this piece of body, geographical location, whatever, and you can see the form. That's the way science is done. The fact that it occurs it is necessary to put it in a journal. There may or may not be copyright acknowledgement from the point if it was taken by the authors of the paper.
Oh, well, that's a different matter.
We cannot, unfortunately, assume that all images in a paper are copyright of the author if they're not given to third parties. That's a problem. And a lot of authors will actually use other images actually without permission. That will happen. And so forth. So we probably won't. We will be very cautious about what images we produce. On the other hand, there is a growing body of reproducing images, and Ross has found all these images on computers or whatever, and so forth. That's separate from that. Where extracting and making this note and representing it in different forms.
Yes. That sounds. So what we're identifying is we're identifying what material is subject to copyright and the source, and where the right terms are and where there is. And you're identifying that there is a low level of we call it nested hierarchy of copyright, some literary material, and leaving aside the database thing. Maybe write separate sui generis, write a particular collection of material that's in putting together and sticking into the article in question, leaving aside that which the potential which concern. Looking at pictures, diagrams, to summarise it, diagrams are likely to be copyright if they demonstrate the originality of this what we talked about earlier, but if they're not, if there is no possibility of the creative exercising creative choices in the way that diagram they're unlikely to be copyright. Photographs are subject to copyright if there is a low level of originality in the composition. By choosing to lightify things. So the most simple point and snap of copyright, copyright, but that thing which is involved with the application of nouns copyright is, there's been recent changes in the context. And the sorts of stuff you're talking about probably are because it's someone's not just gone. Yeah, they've actually.
It would involve skill and judgment.
Right, which is a British test, or the European test is involved with expression around creative choices and choices.
Yeah.
So they are probably subject to copyright. The fact that they're subject to copyright means you can then fall back on what you do with it. If you just take the information from it, the fact, we come back to that again, then what you're taking is not the thing which is copyrighted, protected, and therefore you're all right. But if you reproduce something within the image, then you are at risk, and therefore you go back down to exceptions. It's a hierarchy.
Indeed. I mean, one of our potential strategies, we've also dictated by the technology to some extent, is that we would very possibly create a thumbnail of the picture and put a link to the original image.
Creating links is no issue. That's a particular action which may or may not be an infringement of copyright and justice for
Right, but what I'm talking about here is links to the publicly visible material in a CC biopsy. I think it would be difficult for a public, or most of the open access publishers are well-minded towards this end.
Okay, leaving aside their attitude and the risk of litigation, looking at it from a legal point of view, there is case law in America on the relationship between thumbnails and full-size things which are publicly available, which says that thumbnails are fair use. So in America, you're all right. In this jurisdiction, the relation between linking itself, not necessarily on thumbnails, but the issue of what a link is in copyright terms, is something which is in the process of being resolved by the Court of Justice.
Indeed.
At the moment, it's in favour because they say that if something has been made available to the public, then creating a link is not an infringing act. However, there are concerns. So, for example, if most blatant concerns, if the link takes you to paywall, it is likely to be infringing. So that is an area of ambiguity in the law. So that's the law. Taking a policy decision about what you're likely to do with it, you need to be aware that there is this grey area here. At the moment, you're probably all right, but you need to be aware that this is a
Well, we have, I think, a reasonable set of defences, which are that if somebody objects violently, we take it down, and that will be a common policy. That this has been done in a scientific context, and I think any publisher who argued that we could not link to something which they had publicly displayed on the net is going to suffer in the course of public opinion. I should say that we are not unwrong in the community.
You also, at the moment, legally all right. There is a come through. There's a little interest.
Yes.
But I think it all sounds, I put a disclaimer here. This is uninsured legal advice, which is always bad. So if it's wrong, then you have no recourse against me.
Just like with me. No recourse.
It's okay. I know what the inside of a prison looks like.
Do you?
And the only thing to mention, which hasn't come into this conversation so far, is the internet has been used interjurisdictional.
Yeah.
copyright laws which we covered. It should be emphasised.
Absolutely. And particularly in this area.
And yeah, particularly in this area, particularly even within Europe. So, levels of risk change. What you're doing is very similar, funnily enough, to what journalistic organisations do.
Yes.
Every day. You're dealing with nested rights, you're dealing with people who may or may not be litigious. And you're disseminating information, largely for a public in many different jurisdictions around the world. So you are in good company.
Absolutely. And what's more, they have to do it on an immediate basis.
Yeah.
They can't spend 3 months working out whether they've got...
And asking for permission and waiting.
Now, what I could do, if it might be useful, is I know one of the rights advisors at the BBC, and I could put you in touch with her, and you could have a conversation with her.
That's fantastic. Make sure that Jenny goes...
So if you pop me an email and describe what you're doing, I can forward it across.
That will be Jenny, contact at the BBC. So, we're aware of the things, we're not always aware of the... I mean, you've come up with some wonderful additional stuff that we weren't completely aware of and so forth. Julia Reader in her article said that European copyright was terrible.
And she is trying to simplify it.
I'm sitting here and I'm wondering whether, I think as we're doing this, I'm conscious of the things I'm not mentioning. It gets more.
Well, as you say, it's all about risk. I mean, we're doing this
from an activity.
We're doing this for the public good. The downside is that it may be, whether we mean it or not, it may be disruptive of the current practice because we're introducing new activity. And for example, one of the contracts which Elsevier wanted to get people to sign said at the bottom, you may not do anything which harms Elsevier in the market. We've got that one.
Now, of course, it could be that some publishers, particularly a big one like Elsevier, has its own plans for a text and data mining service of some sort or another, which is what
I think that's absolutely right. But I also think that there's the judo approach. If you feel that some of those companies are likely to throw their weight around, what you are doing gives them a PR positive. You succeed the PR hit.
Absolutely, I would have thought so.
So, the more you can get them on site and you show that you're
So they're good guys.
Exactly. Then there's an advantage.
Well, there is no doubt there's an advantage to them if they adopt our technology and materials and so forth. It is a conservative industry, and there are parts of the industry of which they publish their create databases. And this is, in many cases, a more efficient way of creating a collection of data.
Is it?
I don't know. You say it's a more efficient way. The reason I went off on one there is obviously we're beginning to think about the fact we haven't talked much about the data. Database is right, and unfortunately I have to go. But I mean that's the reason.
That's been brilliant. So just
I was conscious of what you haven't said as much as what you've said. I mean, there's a limit to how we. There's a limit to the practical utility of going into the possible legal minutiae. I apologise.
No, and what I mean, we know we will never get an answer saying you can definitely do this.
Yeah.
You might get an answer saying you'll be extremely poorly advised to do it, but generally it will be this is what we think the risks are, and then we make the decision.
That's the way media lawyers work. They say, it's your choice at the end.
Yes.
And advise you risk.
And that's what we're doing here. So, just for the record, where are you physically located in the country?
The Alison Richards building, just on the
Right, okay, so it's next to huge glass building.
next to, stands to death.
Yeah, indeed. Okay, well, we will meet again.
Well, it's lovely. Thank you very much for inviting
No,
us. It's all very
thank
exciting.
you.
I wish I understood what they're doing. All the time.
Right.
We'll have some demos and stuff.
Yeah.